introducing Cameron Fathauer. He's a leading Kentuckiana lawyer for personal injury and estate planning, having triumphed over a traumatic brain injury of his own in 2015. Fathauer's academic success in both seminary and law school is matched by his dedication as a family man, church member, and a traumatic brain injury advocate, making him a very important pillar of both the professional and community spheres. So with that, I'm going to throw the ball over to Cameron, who is going to present for a little bit on some really important topics that should matter to you guys, and we want to be a resource. And then about 45 minutes, we will open it up to questions and answers and utilize the Q&A tab at the bottom to submit those, and I will address all of those questions later on in the presentation. Cameron, thanks for joining us. So glad you're with us today.
Yeah, thank you, Stephanie. I appreciate that. And thank you, Heather, for all you're doing on the recording side of things. And yeah, so my name is Cameron Fathauer. I appreciate you guys being here in attendance. It looks like some people are still filing in. And so with Debbie's situation, her raising her hand, virtually, and then trying to show her camera, I guess it was news to me as well that I can't see any of you. And so, I mean, one, I don't like the webinar format because it's, disconnected and impersonal by nature. And two, it makes it worse when I can't even see you. So we're just going to go with this, and I'm just going to be talking to myself, which I do sometimes anyway, so it's not that big of a deal. But yeah, so my name's Cameron Fathauer. I'm an attorney in Indiana and Kentucky, and I'm going to start with a story about myself and why I became a lawyer. And Stephanie's heard this a handful of times, but I'm thankful to be able to share it with you. It helps you understand why I do what I do, and maybe provide a deeper connection to me personally. I'm very much, I don't have much of a separation between my personal life and my vocational life. So it was September 18th, 2015, when I was hit by a car as a pedestrian. So I was hit by a car as a pedestrian, immediately in a coma, lifelined via helicopter from Columbus, Indiana, my hometown, to IU Methodist Hospital in Indianapolis, Indiana, where I was diagnosed with a severe diffuse axonal brain injury down my brainstem. And I remained in a coma for about 2.5 weeks. When I woke up from the coma, I had to relearn just about everything. I compared it to an Etch-a-Sketch. I had my life planned out. I was committed to going into ministry. I was taking classes online at the Southern Baptist Theological Seminary in Louisville, Kentucky, while I was in high school. And I was really committed to that. Got hit by the car and got the diffuse injury, shook the canvas clean. And I say the Lord started sketching in a new vision for my life. And what makes it even crazier is that I proposed my wife's hand in marriage a month before the accident. So it was August 2nd, 2015. I proposed to her, and yes, I was in high school. She was a couple years older than me, but I'm so thankful I did that, because marrying her was a huge transformation for me to get better. The inspiration of marriage and the calling to be a husband, to be a father, and I mean, that came later, as you'll see. But yeah, I say I got better because of Chelsea Fathauer. And so Chelsea, we got married, moved on campus at the seminary in Louisville, and Chelsea wanted me to get a lawyer for my injury case. That's how I met Matthew Shad here in New Albany, Indiana. The day I met Matt, he just had this interest in us. He kept saying, "You guys are so interesting." He showed us a ton of favor, took us out for dinner that day we met him. And over time, as he worked my case, I just got inspired to go to law school. I was actually on a trip with my wife, and I've always trusted her. And so I knew if she thought it was a good idea for me to go to law school, that was basically God's will for my life. And I said, "Babe, what if I go to law school?" And she said, that'd be great. It'll be hard, but that'd be great. And So that day I started studying for the law school admission test. I ordered all my books, and there's two reasons why I wanted to go to law school. One, kind of obvious, was because I wanted to help other injured people, like myself. But two, and this is kind of the main reason, because the doctors kept telling me, Cameron, the hardest things for you are going to be higher level thinking, executive function, just using my brain. So I thought to myself, man, if I could do the law school admission test, I could do anything else. So I spent like 6 months studying for the test, and got a high enough score to get into a top 30 law school at the time, Indiana University Maurer School of Law in Bloomington, Indiana, which is when it gets even crazier because so switched out of the seminary track, graduated earlier, went matriculated straight into law school, and it was at the end of my first year of law school, just the day before my constitutional law exam, when my wife gave birth to our first child, Scarlett Jane. And then at the end of my second year of law school, this is this is one of those things again where you I can't see your reactions. I have no idea if anybody's actually listening because I can't see your faces. But this is when it gets crazy. So it's at the end of the second year of law school when my wife gave birth to triplets. So triplets, that's three human beings at one time, one birth. So we had two pregnancies and came out with four children, all during my time at law school at Maurer. And so somehow, again, by God's grace, we still graduated, passed the bar exam, licensed in Indiana and Kentucky. And I worked for the same attorney who worked my case 7 years ago. So it's just a huge testament. My life is a trophy of grace and unmerited favor. And so I'm just thankful to be here doing what I do. And I've developed some sayings. So I do personal injury law, and that's the main thing the firm does here, and they've been doing it for decades because what happened to me, and I do estate planning because of what could happen to you. And with the estate planning, my last name is Fathauer, Fathauer. Before your last hour, call Fathauer. This is when I know you're all laughing right now, so that's yeah, I know. I appreciate the applause and the laughter. You guys could put in the chat that you're laughing. Maybe that would help. But anyway, so that's why I became a personal injury lawyer. That's why I became an estate planning attorney. And it was actually Larry Shadd, the founding partner of the firm, who did estate planning. That was his specialty. He did it for decades. He passed away a couple of years ago. And so I kind of took that over when I became an attorney at the firm and developed it into my own thing. And it really connects well with my story. And so the other reason I share that story with you is because you never know what can happen. You never know what can happen. So this is whenever I have a PowerPoint for this, I have a slide that shows this. This is a 3D model of my skull, my natural skull. So I lost about a third of it upon impact. It was shattered, and I was yeah, so they used this to make the piece they put on my skull right here. Thankfully, they did a good job because almost no one can tell that I had a brain injury, especially one of this magnitude and severity. So, but yeah, if we were in person again, see, maybe you guys can just come to my office. You guys can just schedule an appointment with me, and you can touch the skull. It was actually my youth pastor who said, a very youth pastor thing to say while I was at the hospital. He said, I can finally pick Cameron's brain. So, yeah, so you guys could hold this. My consultations are free. And so that's what I'm getting at is you never know what can happen. So this is why you guys got to get an estate plan in place. Estate planning is very important, but everybody puts it off. Everybody puts it off, and that's why I'm in a good position, I think, to encourage people to get it done. And I'm not some third-party financial advisor or something where I tell you to get one done and then I send you somewhere else to go get it done. I tell you to get it done, and you can come directly to me and I can help you get it done. So that's the benefit of me being here and sharing this all with you. So on the PowerPoint, the reason I don't have a PowerPoint is because they're boring and they're not interesting. And I feel like it's more interesting for me to just talk to you. And I prefer to be more, um, I don't know if it's, I guess it's informal in this manner because I want it to be kind of conversational, although we're going to designate time for a Q&A in the latter 15 minutes of this presentation. So I'm just going to get into the presentation entitled Using the Law to Support Those You Love. So the first estate planning document everyone needs is the power of attorney. Power of attorney, very important. There's two types of power of attorney. There's the general power of attorney, and the general power of attorney is for all transactional decisions, any agency things acting on behalf of someone else. So signing for them, withdrawing things, putting things into an account, um, accessing an account, whatever it may be. I use the example of, so the, let's say the internet is in one spouse's name and you're on the phone trying to change the payment method or switch out of the service and you can't access the account. They're like, well, we can only speak to the husband or the wife and some spouse. And but if you had the power of attorney, basically you can do everything for each other's on each other's behalf. And that's kind of a silly example. Other examples are, like I was in a coma, or even if one of the spouses or friend goes overseas and there's something they need to take care of, you can take care of it for them on their behalf. So general power of attorney, very important. And you want your power of attorney to be very specific and comprehensive. So with all estate planning documents, you can get these things online. You can get forms online, but they're really cheap and really low grade and not effective, especially for a power of attorney document where financial institutions are reluctant to honor them out of concerns of fraud. So they are reluctant to honor them because they're concerned about you taking advantage of someone or trying to act on behalf of someone else when you don't actually have that authority. And so you want your power of attorney to be comprehensive and specific. And by specific, I mean it names specific powers that this person has or lists powers this person does not have. My power of attorneys are very comprehensive and very specific, and they cover all the relevant statutes supporting each power. And there's another reason to not go with the forms. And I do think this is a good way to start this kind of a topic because, again, you can get forms online. People, Dr. Google, physicians don't like that, where everyone goes to Google to solve all their medical problems. It's the same issue with legal problems, but there's, I can't really think of a cool way to say that, like Doctor Legal or something, or Judge Legal. I don't know, but anyway, you know what I'm talking about. So the reason the forums aren't good online is because you want to have local counsel. You want to have someone, a licensed attorney in your state, maybe even in your city, in your county, in your area, because they will understand the rules best. And this is the biggest reason, because it's good to have a relationship with an attorney. You never know when you're going to need one. And because when you have any issues, you have any questions, or someone needs to talk to someone, you've already got that relationship developed. You've got a point of contact. You've got a person to go to when you have issues or questions. And I mean, if something does go wrong, and you just filled out the form online, well, who are you going to call? You're going to call some customer service representative in a foreign country, maybe. So that's not the ideal situation. So this is why it's good to have a local attorney in your area, licensed attorney in your area, helping you with these things. And the other reason is because if we're talking about a will or a trust, you want to make sure your children are going to have someone you trust, someone they can talk to, and they'll get along with, they'll have a pleasurable time with. And so those are just things to consider on why getting a local attorney is important. and it's worth the cost. So that's general power of attorney. The other power of attorney is called a healthcare power of attorney. You're probably familiar with this. I'm sure a lot of you are with the context of this webinar. But healthcare power of attorney designate someone to act on your behalf for all medical care decisions, regardless of HIPAA accessing records and things like that. Now, I will say, because we're so close to Indiana, and I'm an Indiana attorney as well, I'm going to mention this. Indiana changed its healthcare power of attorney law in 2021. It became it was enforced at the end of 2022. And what the change did is it basically created a more flexible document to combine the advanced directive with the healthcare power of attorney. So really, it's just kind of one document where you spell out your directives for end of life care decisions. You want to be on life support, you want to receive artificial nutrition, you want to receive pain medications or not, and you can even handwrite specific instructions, like I want to receive this medication or pain med, but not this one, or I want to donate this organ, but not that one. You can, or even my favorite pill, I want this pillow at my deathbed, or something. You can just put whatever you want there. That's kind of the point, within reason, of course. But also on the same document, this is where you'll name your power of attorney, your advocate, your agent for your healthcare decisions. And again, these are great things to have. Everybody should have them. If you're over the age of 18, by law, you're able to get these documents. You're able to sign your will. You're able to sign your power of attorney. And I think people put this stuff off, and there's no reason not to get it done and just move on with the peace of mind, knowing you've got a plan in place. And that gets at a benefit of doing the estate planning. And I say estate planning is essentially burden reducing. So burden reducing the burden for other people. So that's probably one of the number one reasons estate planning is important, is to limit family conflict. I'm sure some of you in the audience understand the headaches and the conflict that can arise when a loved one passes away, and when there isn't a plan in place, or there was a plan in place, but it's a disaster. It was poorly made. It was made with some Google online form or something else. It wasn't updated. And so this is why it's good to have a plan in place and make sure that plan is made by a local attorney. And so it's estate planning is burden reducing, it's others centered. You're trying to make things better for your loved ones, trying to make things easier for your loved ones, lowering the stress, lowering the cost, lowering the confusion, trying to make things clear and easier for them. But of course, there is a benefit to you right now, and that's, again, the peace of mind primarily of knowing the plan is in place. And again, you've got a plan with a trusted local counsel. So general power of attorney, healthcare power of attorney, very important. And I touched on the advanced directives that are in there as well. And that's kind of point number 5. So I don't need to mention that again, really. I assume you guys have the handout. And so we're talking about the same thing. And other reason I didn't mention you want the general power of attorney is to avoid guardianship proceedings. So guardianship is what is an expensive proceeding, and it can be kind of humiliating for people, because you're basically saying, in the eyes of the law, you're determining this person is incompetent, and they're basically now viewed as an infant in the eyes of the state. So you become the guardian, you're appointed over them, kind of like a parent over a child. So that can happen with your spouses, especially in the context of cognitive decline, neurological disorders, things getting worse for people, which is what happens to most of us as we get older. So making sure you have that power of attorney in place, authorizing an agent, someone else you know, you trust, normally a spouse, to make decisions for you on your behalf, someone who can sign off on documents, who can get you into a home, get you into the rehab, get you into the care that you need. I will say, however, it's not perfect, because I have had cases where someone had a power of attorney, but it wasn't good enough because the spouse who had these neurological issues and cognitive decline issues, the spouse was stubborn, as a lot of older people are, young people are too. Like my wife is very stubborn, but I love her to death. She's stubborn on good things 99% of the time. But so if they're stubborn and they're non-compliant and they're not doing what you know they need to be doing, then you would need like the guardianship. So that way you could basically force them to do what they need to do. So that's kind of the extra step, but that's not in most cases. Most cases, the power of attorney will suffice for all things as long as it's comprehensive and specific. Now, number two, the will. So there isn't a lot to say about the will, except that it's the classic form for distributing your assets when you pass away. And a lot of people understand kind of the general idea of a will. It's just a place for you to put down your legal last wishes for what happens to your stuff when you're gone. But what a lot of people don't understand is, and this is something I try to address in my presentations, is the difference between the will and the trust. And the main difference is the will, no matter, wills have to go through what's called probate. Probate is the statutorily authorized procedure for distributing your assets when you're gone. So probate takes by statute a minimum of 6 months. You have to open the creditor window and it has to go on for a few months. And then you have to give notice to all the different beneficiaries. And so it's a time consuming process. And what that means is that's a process that for some people, it's really hard having to constantly be reminded of the passing of a loved one. And just taking all that time just to get the stuff, you wanted your son, your daughter, your friend, you wanted them to get, instead of them getting it like right away, they have to go through this legal process. And we all know government work is not fast. So wills have to go through probate. Now, not all states have to go through probate. And by a state, I mean not just your home, but the value of your assets when you're gone. So in Kentucky, estates that are worth more than $30,000 have to go through probate in order for you to get access to the account or the home. You have to probate and petition the court. That's generally the case. Sometimes, and I've been learning this recently actually, where even if it is less than $30,000, if the person is not a spouse, a child, or a preferred creditor, then it'll still have to go through probate. So if like I've got a situation where it's not a child of someone, but it's actually the parent who's trying to get access to a vehicle that was owned by the daughter who passed away. So for some reason, the courts, even though the statute says they should be able to get this asset right away, because Kentucky has a little more streamlined and structured forms for this than Indiana does. They only allow you to avoid probate if you're a spouse, child, or preferred creditor, and it's a small estate. So I can always clarify these things in the Q&A or privately. And I will say, if any questions have arisen during this conversation, I recommend that you write them down. And the Q&A, I doubt we'll be able to cover everything. And what I encourage is the best thing to do in these kind of situations, with all legal questions, a lawyer's always going to respond with something like, it depends. So it depends. And because of that reason, I'll do my best to answer questions in the Q&A, but I want you to know that you can always give me a phone call or you can send me an email. I believe my email and phone number is on that form that's been passed out. And Stephanie or anyone else at the Norton Neuroscience Resource Center could probably give you my contact information as well. And I actually generally try to be as accessible to clients as I can. So I usually give out my personal cell phone number. I just want you to know I'm here and I'm able to help however you need. But if you have specific questions, feel free to schedule a free consultation with me and we can talk about your specific needs because everybody's different. We all have different needs. Now, so wills have to go through probate if the estate's over $30,000. Indiana changed at the end of a few years ago. Indiana upped the probate threshold from $50,000 to $100,000. So now a lot of states, not a lot, but I've seen a number of estates that are less than $100,000, where the asset is less than $100,000. Excuse me. And it can avoid probate. And the smallest state situation, which would be less than $100,000, is much smoother in Indiana than Kentucky. So I have it's a much smoother process in Indiana than Kentucky, and so I'm happy to help with either one. But if the estate's over 30,000 in Kentucky or over 100,000 in Indiana, it goes through that 6-month minimum process. I say 6 months, but that's like in a perfect world. It always takes longer than that. And so question is, I'm sure you're wondering, Cameron, how do you avoid probate? How do you avoid that 6 months of just painful, slow and long and lengthy and annoying process of probate? Well, you can avoid it in a few different ways, but in this context, the legal instrument for avoiding probate is the trust. There's different kinds of trusts, as you'll see with number 3 and number 4. There's the living trust and then the irrevocable trust. The living trust is like if you had to choose between a will and a living trust, the living trust is the way to go because it's much more powerful, much more flexible, it's private, and it avoids probate. So it avoids that process. I think of it like a vehicle that you create for your estate, and the vehicle is being driven by the trustee, which can be you during your lifetime. And on the way around the courthouse, you're picking up assets. So you're picking up assets. In comes your life insurance. It takes a seat in the trust vehicle. In comes your house. It takes a seat in the trust vehicle. And then in comes your bank account. It takes a seat in the trust vehicle. And then it's just you pass away, and now you have a new driver in the trust vehicle, the successor trustee. So this is the person that comes in when you're gone. And then they drive it around the courthouse, and then they drop off those assets or portions of the assets. So this is why the analogy isn't perfect, because obviously we don't split people in half and give them away, but you get the idea. You drop off assets, portions of the estate to children, to nonprofit organizations, churches, to friends, family, other family members, and then you do all that privately. You do it all on your own time. So I know I've never heard anyone say anything bad about a loved one having a living trust. I hear it all the time. So thankful mom had a trust. I'm so thankful dad had a trust when he passed away, because it just makes everything so much smoother and easier for your loved ones. And the other reason to avoid probate is the cost. So I mentioned and I kind of emphasized how long it can take, but that's not the big reason to avoid probate. The big reason is because of how expensive it is. So on average, probate costs between 3 and 10% of the estate. So if your estate's worth $500,000 at your death, well, 3 to 10% of that can be $20,000, $30,000. That's not going to your loved ones, but is instead going to the courts and to some attorney. And of course, I would make a lot more money just probating all of your estates, but I think it's in your best interest for me to give you the advice of getting a trust to make things easier for your loved ones, make things easier, and you have the peace of mind knowing something is easier for those you leave behind. And so I try to advocate and encourage people to get that done, even though I would make a lot more money, encouraging you to get a will. And I do think this is part of the reason estate planning attorneys don't talk about the true benefits of the trust, because if they're just estate planning attorneys, they make a lot more money off of probate than you getting a trust. Now with the living trust, this is again something you create during your lifetime. If it's spouses, it's called a joint trust. And this trust, private avoids probate, but living, it's also known as a revocable trust, living trust, meaning you can change it, you can amend it however you want during your lifetime. And so if which is great. Again, the flexibility and all that stuff is great. So the other trust is called an irrevocable trust, which is, as the name suggests, irrevocable, irrevocable. You can't change it once you set it up. And that's kind of the magic of it. That's the way it works, is you set it up that way. And the reason people have irrevocable trust, and this is relevant in this context, I noticed that a lot. Irrevocable trust, people use it to protect assets from nursing home costs, Medicaid coming in and taking the house, taking all the assets, draining your loved one's stuff. So you put those assets in an irrevocable trust to protect those assets from creditors like Medicaid. Now, in order for that to actually happen, though, Medicaid has what's called a 5-year look-back period. So you put the asset in the trust, and 5 years has to go by without your loved one going into a nursing home or you going into a nursing home. And after that, then Medicaid will no longer see the asset as yours. They will see it as owned by the trust. Now, I do not see a lot of people ending up wanting an irrevocable trust, because a lot of people don't want to go into a nursing home. But again, in this kind of context where we've got concerns about dementia and Alzheimer's and cognitive decline, where we're worried about that, or that might be a foreseeable event, the irrevocable trust can be a wise choice for people. And you can always go from a will to a trust. There's no problem going from a living trust to an irrevocable trust. Like, those transitions are not difficult. And the other part of the, let me think. I need to take a drink. And I will mention with irrevocable trust is protecting the asset and saving on estate taxes. Now, Indiana in 2013 abolished the estate tax. There's no inheritance tax or death tax in Indiana. The only tax you have to worry about is the federal tax, which right now is $13 million for an individual and $26 million for a married couple. So most people aren't worried about that. Most people aren't in that situation where they need to set up an irrevocable trust to avoid those kind of taxes on their estate at their death. Now, if you do Dr. Legal Google, again, I don't have a name for it. Maybe I'll come up with one soon or after this presentation when it doesn't really pertain to you anymore, but that's what usually happens. But we'll see now, just blanked on what I was going to say. Estate tax in Kentucky. Kentucky, Google it. Kentucky will say there's no death tax, inheritance tax in Kentucky. But that's not exactly true. That's not what the statute says, because the way the taxes work in Kentucky is depending on who the beneficiary is, and depends on how close that beneficiary is to the decedent, the person who passed away. For example, if you die and your will says everything goes to my spouse or everything goes to my children, then there's no tax. But the further out you get from your biological next of kin, your legal next of kin, you could say, the further out you get, the bigger the tax gets. So let's say you want to leave everything to your cousins. Now you're talking about a 6 to 8% tax. You want to leave it to a friend, that's a 16% tax. And I did that for someone recently in Kentucky, $800,000 going to this one person who was a friend, and 16% tax. Although there are some ways you can get that reduced a little bit, depending on if you file it quickly, which I did, to get it down to like a lower amount. But anyway, that's a large tax, and that's how it is in Kentucky. But no such thing exists as of right now in Indiana. So irrevocable trusts help protect assets from the nursing home, or just protect assets in general from taxes or any other creditors that you might be worried about coming after an asset. Because and this is part of the reason people don't normally want the irrevocable trust, is because the way it works is you're surrendering your rights to the asset by putting it in this trust, which is controlled by a third party who is not yourself, and you are not the beneficiary of it. I mean, you can receive benefits from it. Let's say you put your house in an irrevocable trust. You can still live there. You can still benefit from the income, you could say, but you can't own the principal. You don't own the principal. The trust owns it, and it's controlled by a third party, which can be your friend, or it could be a corporate trustee like a bank, uh, things like that. So that's how that works. And we've got a few minutes before the Q&A. And so the last part to mention, we already talked about the living wills, advanced directives. The reason there's a slash is because living will, it's a synonym for an advanced directive. Again, these are end-of-life care decisions, life support, artificial nutrition, pain medication, those type of things. And you can spell that out in Indiana on one document, and you can do it that way in Kentucky. But it's just sometimes it's good to have a separate one as well. It just depends on the needs. Now, last point is deeds. So whenever I set up a trust for someone, I almost always do a package. Well, same thing with a will. I do a package where you get your will, you get your general power of attorney, healthcare power of attorney, advanced directives. You get all those things at one time, because a lot of times people come to me saying, I want this one document, I want this one thing. But then they're like, oh yeah, we don't have that, we don't have that. So it's good just to get it all done at once, and it's cheaper and it saves time to get it all done at once. And so when someone gets a trust, the key to the trust is funding the trust. If you recall, the vehicle analogy, so you got to pick up the assets on the way around the courthouse, and that's the picking up the asset, picking up the life insurance, picking up the bank account, picking up the investments, picking up the house. Like that's the funding of the trust. Once the asset takes a seat in the trust vehicle, that's funding the trust. So I include the deed to put the home in the trust, because in order to put a real property into a trust, you have to draw up a new deed, which is what an attorney can do. And so I include that whenever I do a living trust package for people. So, but there are other things you can do with deeds in Indiana. It's called a transfer on death deed, and that will avoid probate. What it means is you're basically gifting the property to someone, and at your death, it automatically goes to that person upon your death. And there are complications of doing it that way, but that's the TOD, the transfer on death deed, is only allowed in Indiana. Kentucky does not have something like that. Now, in Kentucky, you can do a life estate deed. You can do those type of things where you gift the property to someone now, but you retain a life estate. You can live there as long as you want, and you can use those things as cheaper methods to avoid probate and to avoid that stuff. So, I think I've covered the general stuff, Stephanie, and I think we can I can actually hear from people,
Yeah,
or I guess I'm just
absolutely.
going to hear from you.
Yeah. So I have a question, a couple of questions that have come in. One, I might need a little bit of clarification from Danny. I didn't know if Danny, you wanted to, I can unmute you and you can ask Cameron your question, but only with your permission. The question that came in about, it just says ours is a general durable power of attorney with a question mark. So I don't know if we need to expand on that or if you maybe can answer. I know you spoke a little bit about it, but just the general power, durable power of attorney, and is that acceptable for most situations?
Yeah, no, good question, Danny. So, general durable power of attorney is the best. Like that's the best one, and that's the one I always do. So, durable, what that word means is if something happens to the person who's authorizing this power of attorney document, the grantor, the signator, the person that's signing the document, if they become incapacitated or incompetent or something, that the power of attorney remains in effect. That's what it means by durable. But it, I always set mine up that way, and that gets at something. The two types of power of attorneys. There's an active power of attorney and a springing power of attorney. And I never do. I mean, I will do it if the client wants it. Putting my client's interests ahead of my own. Normally, if it's advisable and reasonable and legal. But the springing power of attorney, what that means is it doesn't become effective until you become incapacitated or incompetent or you're deemed so by a medical professional. I don't advise those and I don't normally do those for people because when you need a power of attorney, normally you need it like right then. You need it now. You don't want to have to wait to take someone to get checked out by a doctor and then have that doctor write a note, which can take a decent period of time. And sometimes that person's just non-compliant. They don't want to get checked out. They don't want to go to the doctor. They don't want any of that stuff. So, and that can be a humiliating process in and of itself. So, when I do a power of attorney, it's almost always durable. So, it's effective regardless of what happens to the authorizing person, the grantor, and so it's effective right away. It's active. So that's the other type. So springing and then active power of attorney. It's once you sign the document, this person is your agent. This person is, and normally if it's spouses, you set it up so you guys are each other's. And just because you're married to each other doesn't mean you get the right to do everything on each other's behalf. But if you sign that document and have that power of attorney in place, then yes, you can do everything on each other's behalf. And then really the two become one.
Mm-hmm. That's what I was gonna say. And we have some, that was very well said. I actually clarified some stuff for me that I did not know. A couple really good questions. So is a home exempt from the Medicaid look back in Kentucky?
No, it's not. It's not unless it's in a trust or you do a life estate deed, or there are like other exceptions for homes. Like for example, with Medicaid, if if so, they're called the community spouse. So if one spouse is in a nursing home and the other spouse is not, the spouse that's not in a nursing home is called the community spouse, and they still have the right to live at the house. Medicaid can't touch the house, so that's fine. Or if you have a caregiver, uh, whether it's a family member or just someone else. Normally, I think it actually is supposed to be a family member, but uh, I think it can just depend. But as long as the caregiver was living at the house for, I believe it's 2 years consistently for the purpose of caring for someone, then they can't take the house. So those are some fact specific ways to get around that. But in general, yes, Medicaid, the home is not exempt in and of itself normally. So unless those circumstances apply.
Okay, thank you. All right. Can two people have healthcare power of attorney? I'm the daughter and primary caregiver for my mom with mild dementia. My dad doesn't go to appointments because he works and is not familiar with the medical stuff. I know he ultimately would be the main decision maker on life support decisions, but I'm making all the day-to-day decisions. Great question. Very common situation too for some of our patients and care partners.
So, Stephanie, help me understand what
Mhm.
exactly is the question. So, is the question, yeah, just
So
help
I
me
think the
understand.
main thing is, can two people be healthcare power of attorney? Because the person with dementia has both the daughter and the spouse of the patient caring for her. So how should a legal document be written so both can
Yeah,
still making
yeah,
decisions?
yeah. Okay. So, yeah, I encounter that situation a lot, especially I encounter it mostly with children. So the parents are doing their estate planning and like they're setting up a trust and they want to name so and so the successor trustee, but they've got like two kids and they don't want to pick one kid and single out the other because they feel bad. So like, is there a way to have both of them? Generally, I advise against that because if you have two people, normally you have to have both of those people present to sign off on everything. So it's usually not practical or advisable in that sense. But there is a way to draft it, like the way I'll draft it, where and or. So you've got Jimmy Doe and Johnny Doe, two children of John Doe, and they're going to be the healthcare power of attorney. And John Doe wants both his kids to be power of attorney, so he just says and or, so they can act together or they can act separately. So it'd be authorize Jimmy Doe and or Johnny Doe to be my power of attorney for healthcare decisions, general decisions, whatever it is. You can do it that way. It's not always perfect, but that's the way you would set it up in that situation.
Okay, great. Let's see here. What happens if the successors you name in the irrevocable trust die before you do?
Oh, it's a great question.
Mhm.
So irrevocable trusts can't change them, generally speaking, but you can change who the trustee is. You can change that as long as it's not yourself. You're fine. You can change that. You can change it from a. Uh, I mean, and that's why it's normally safe to have as an alternate trustee an alternate successor trustee, have it be a bank or a corporate trustee, someone you know that's usually always going to be there, um, uh, because normally they're there because a bank isn't really a human person who's going to die. It's a an entity we've created by law. So um, that's a safe way to do it. Or again, you can just appoint someone different. The main things you can't change are like the terms of the trust as pertains to who gets what or how much they get. Those kind of terms can be difficult to change. And the number one change you can't do is benefit yourself. You can generally benefit yourself with like the income of the asset. Like if there's interest on, like let's say you put a lump sum of money into a trust account, you could say, and you can be entitled to the interest that is from those investments, but not the principal. The principal would be the whole asset. So you can't take the whole $30,000, but you could take the $100 a month that comes from the interest or the dividends, whatever it is. So those kind of terms you really can't change those. There are ways, it's called decanting a trust, but um, those are expensive and difficult. So the whole point of it is to protect the asset.
Okay. My mother has been paying for 24/7 care to stay in her home. Her funds are dwindling, leaving only her house as her last asset. Can we still protect her house if she goes into a nursing home?
Okay, so her funds are dwindling. Uh, why are they dwindling?
From the 24/7 care that they're paying out of pocket for, probably.
Oh, okay, that's what you said. 24/7 care. Okay. Um, yeah, you probably could. Well, okay. Okay, so I mentioned the life estate, but the life estate is a cheap way to avoid creditors like Medicaid or nursing home from taking the asset. But again, it's the same rule, the 5 year look back period. So the day you do the life estate, you have to wait. You have to go 5 years without going to the nursing home for it to apply. And some people think just deeding the property to a loved one uh, will protect the asset, but that's not true. Again, you got to make sure you do it the right way. Have an attorney do it to be a life estate, or again, you put it in a trust. So, um, in that situation as well, there are ways to save assets if it's called crisis Medicaid planning, where someone needs to go into a nursing home like tomorrow, and you're worried about losing everything. Well, you always make sure you talk to a professional that's not Medicaid about your rights and what you can do with your assets, because Medicaid is going to advise you to sell the home. They're going to advise you to do things that you don't actually have to do. So you want to make sure you talk to a licensed attorney, especially an elder law, elder care attorney who deals with Medicaid and estate planning matters in that way. And so if there is a crisis planning situation, you want to, any attorney will tell you that they can save 50% of the assets. So most likely, if if that person has to go into a home within the next 5 years, the home will have to be sold. But Medicaid doesn't necessarily have to get all that money. You can still retain 50% of those assets, 50% of the money. So the home's worth $100,000, you can keep 50,000. Medicaid won't tell you that, but the attorneys who specialize in this can help you get that.
For a disease that's so complex anyway, and then to add on the legal and financial planning, it's just, people are so vulnerable, and this is such a great area. So I'm just grateful for your expertise and being able to share some of this. It's something we struggle with
Happy
as
to.
professionals, just because we want to navigate and answer so many questions for our patients and guide them in the right situation. And we hear the stress, and we know the stress because we've lived it personally and we see it professionally. And it really takes a village to kind of pull together our resources and our knowledge to share that with everybody. So um, that's exactly why we wanted to have you on here today, to kind of help answer and clarify some of those things. I know some of it seemed clear as mud, and some of it actually seemed very clear. So again, can't stress it any more than, if you can plan as early as possible, do so for yourself, for your loved one, but also find the right pathway to getting that information, whether that's Cam or somebody else. It can be kind of a tricky thing to navigate, and so we're all here to support you guys as much as we can. We don't have any other. Well, hang on, I say that we had one more coming. Nope, I think that's it. So we are finished with the Q&A part, but I wanted to shift your all's eyes to the webinar chat. Heather put in links to where our YouTube playlist or channel is for Norton, where we store a lot of our programs, and that's where this webinar with Cam will be stored on there as soon as we get this uploaded. So there are a couple different pathways you can use to finding our videos. And so that's through the link that Heather has there. That's through the YouTube, and that specifically goes to our memory page. Or you can also go to nortonhealthcare.com//
Yeah,
neuroeducation. So I never know which one that is. /
yeah.
Right? Okay.
Sorry. Okay, wait. No. Let me know when I can talk.
Oh, sure.
I mean, I've done a lot of talking.
No, you're good. Neuroeducation, and click on memory. You can find all different disease states there, but for the memory programs, you can find that. And again, that's where Cam's presentation will be. It's important for us to have that on there. So thank you, Heather, for recording that. And Cam, yeah, any closing words? Or, oh, we have one more question if you have to, if you want.
Well, I just wanted to, it doesn't look like I can post a chat in the general message. So I want to send this. This is a link to more of my story. It's got pictures of my triplets and the kids and the family, and happy to share it with people if you're interested.
Yeah, I was gonna say, Megan's gonna send out, we have the emails of everybody that registered, so we can send out any additional pieces of information, and we'll probably go ahead and do that, Cam. If you'll send me that link, I'll
Yeah,
add
I
that.
just sent it, and
Oh, there it
she
is.
can,
Perfect.
yeah, she
Yep,
can, or someone can share it with everybody else. That'd be great.
yep, I can certainly
But
do that.
yeah, one more question. Happy to talk.
Yes. So would you say irrevocable trust is the best way to go? Emphasis on the best.
Generally, no. I don't think most people need it. I don't. Well, okay, I say it again. This context might be different. There are ways to protect assets without the irrevocable trust, but the best way is the irrevocable trust. So if you're concerned about nursing home, concerned about that, and you've got a time period, 5 years or so, you know you're getting ahead of things, then yes, just establish the irrevocable trust. But I think most people in the general American population should have a living trust, a revocable trust, because it's way better than the will. Does everything the way you want. It's not for everyone, but I think, again, I say most. I think most people want to make things easier for their loved ones, avoid the hassle and all that stuff of probate and the costs. But the irrevocable trust, I think, is for a select few people who need that protection for the asset, or they're so wealthy they are concerned about
Mhm.
taxes.
Good. One last question that just came in. I think this is a good one and possibly can wrap around.
Or sorry,
Oh,
I forgot to mention the special. There are special needs trusts which are
oh, yes,
irrevocable
yes, yes,
normally,
yes.
and
Yeah,
special needs trusts. So if someone's on Social Security disability or SSI, and you're concerned about them getting a lump sum of money, you can have a trust set up for them, or we can set it up now to protect, so they can get that money, but get it in a legal way, so they don't lose their benefits.
that's a
So
great,
that's
great
something to
addition. Yes,
think
no, I'm
about.
glad you mentioned that. Is there a way to limit my wife's control of financial assets to protect against her falling for fraud attempts? So this is going to be a dual legal and social work answer, I think.
So so I mean, I would need to know more facts. Like, so
Well,
is the wife, is she
so
just like,
my
does she have mental problems, or
my
is she just
assumption is
um
that, yeah, so this is the same person asked about 24/7 care. So or mentioned that their loved one has 24/7 care. So there's probably some capacity
yeah,
issues at
yeah,
play. And
yeah.
so of course that always makes all of us more vulnerable. These people are quite professional at how they get our finances. So is there a legal way to control of her assets to protect her against fraud?
I mean, I would have to discuss it with the
Mhm.
person privately, but I mean, generally, I would think practically you just want to limit her access to those
Mhm.
accounts. Maybe take the credit cards, switch the account to your name alone, uh, or make sure you have a power of attorney over her. Excuse me, those
Yeah,
kind of things. Um,
I would say the
and
same. Yeah. And
yeah,
I think too, it takes a kind of a multifaceted approach to answer this, I think, because so if it depends on her level of capacity, if she is still confident to make her own decisions or has the capacity, um, we can work with you. And I say we, our social workers here are very good at working with you on how to do exactly what Cameron just said of how can we strategically reduce her access to money or put safeguards in place. So a lot of families will stop mail from going to that house and set up a PO box, for example, if mail fraud is an issue, or adjusting the cell phone number to being the main number is the loved one, or things of that nature. We call those things compassionate deception. But we also, you want to be respectful of that person and have their dignity too, and having a discussion with them of, let's work together, because there's a lot of people out there that are out for no good, and not necessarily highlight it's because mom has a problem, because sometimes people want to hold on to their independence. But a lot of times, maybe Cameron, I mean, would going the route of if that person's not agreeing to having you being on the bank accounts or taking over those finances, It is a discussion with your primary care or your neurologist of, is she able, or should she be able to manage her own finances? And then if not, due to her cognitive ability, maybe we need to get guardianship or conservatorship.
That's what I was going to say. Like last resort, best
Right.
best way to deal with that situation is to get a legal guardianship over the person, because then if there is a fraud issue, like the person does, fall for some scam, then you do have a legal proof that says, well, they weren't able to consent to that contract. They weren't able to, and so then you can get the refund. Then you can most likely mitigate the situation. That would be the best way to mitigate the situation, because you've got the proof that nope, they didn't have capacity to consent. Uh, I did that recently with someone. Uh, they bought a brand new car, and then a few months later, they were determined incompetent by a court, and a guardianship was put over them. And so I contacted the dealer and I said, look, this person wasn't of sound mind. They didn't have the testamentary capacity to consent to anything contractual. So we didn't get a full refund, but we got a partial refund. So
Agree for advocating, yeah. I think that is it, but I want to throw out our phone number if you are a patient of ours, and even if you're not, just you can always access us as resources too for questions just like that came in where you might need a little extra hand holding on kind of those social supports and how to navigate those conversations. But also we can get you in touch with Cameron too. So our phone number here at the Norton Neuroscience Institute is 502-394 6460. I'll put that in the chat. And we are sending out an email with resources, including Cam's handout that has his contact information. Make sure everybody got that. And links to our YouTube educational programs. So I think with that, we will wrap it up. And Cameron, thank you so much for your time and your information. It's very, very valuable. And never hesitate to call upon any of us for to be your guides and support. So thank you all for taking time out of your day today, and we will all keep in touch.
thank you.
Thank you.